Looks like we're live. Welcome to the Bradley J. Show. And we're here with Michael Coyne, Dean of the Massachusetts School of Law, who's checking in again for a kind of a recap on the, the, the potential crimes of ex-President Trump and his colleagues, if you will. Some would say colleagues, some would say cronies, some would say Confederates. But we want to just kind of get a catch up on all that has transpired legally since we last spoke. So how do you do, Dean Coyne?
I'm doing very well. It's been a long time, too long since we've had a conversation.
Yeah. What's going on over the school at this? What is it, January something? Is it vacation?
It is, but next week we start orientation. This week I've been running around. A number of our graduates have been very successful in their careers in public service. In fact, today, at noontime or thereabouts, the Lieutenant Governor, Kim Driscoll, will be sworn in. She's a graduate. Our district attorney up here now is Paul Tucker. He's a graduate. I saw his swearing in on Monday, and yesterday I was down the Cape and the Islands for Rob Galliboy's swearing in as the new district attorney. So our folks are doing what we always hope is to really people of integrity go into public service to make a difference, to really try to help others. And it's a very, very busy week, but a very proud week to see how much these folks have accomplished and how much of their lives they've committed to public service and to make a difference, especially when we can see, and we're going to talk about some of the problems of some of these so-called public servants on the national level,
Right.
where in Massachusetts, I think we're very, very fortunate that we really do have a pretty high level of commitment from our public servants to try and work together to make a difference, to make people's lives better. And I think Governor Baker embodies a lot of that as well. So let's hope that the next administration does the same and we continue to make progress in Mass. And I'm very proud of our folks in that regard.
How long have you been dean now?
Um, I think since about 15. So what's this, 7 years at this point? I guess this will be the 8th year. That sounds about right.
So you and I have been doing shows since before you were assistant dean, I think. So that means
Yeah,
we've been doing shows for about 8 years.
that's right. That's right. It's been a long time, and I used to love. I still love our conversations, but as much as my wife hated me driving off at midnight, I really enjoyed our late night talk fest. So
Well, you've given me the best years of your life, and I appreciate that. All right. So I guess a standard way to go, might as well go the standard way, is to just take a look at the list of potential charges for certain things that the ex-president might face, and what the hardest evidence, the unavoidable evidence is, and what he might be charged, the actual charges might be. And I want to start with something that doesn't come up a lot, and that is there such a thing as criminal negligence for not a dereliction of duty, criminal negligence, refusing to honor the oath? You take an oath, and clearly you sit there and watch domestic enemies trying to take over the Capitol, to overthrow the government, and you do nothing. Isn't that a clear, at least dereliction of duty? What's the high end of what could happen for that?
you've got to break it down a little bit and go and take a step back to try and think about it. I think it's ironic that we're on the verge of the anniversary of January 6th here as we do this. I don't know whether that was intentional or not, but that's obviously the acts that took place on January 6th and the president's and his staff's involvement in those acts would be the most serious by all accounts. And the question of whether he was a conspirator in those events or whether he orchestrated and encouraged all of these folks to do all of the horrible things that were done on January 6th. That's the issue there. And whether it was intentional or what we would say from a legal standpoint as a principle, and it's similar to what you propose as criminal negligence, it's willful blindness, right? You can be convicted of crimes because in essence, you knew and you turned a blind eye to the danger. I think the evidence says we're way past that for the events of January 6th. I just saw the other day a release from one of his secretaries that was prohibiting the engagement of the National Guard and the National Guard's use of weapons either the day before January 5th, 6th, or January 4th. The fact is that there was an awful lot of information out there that this was going to be a violent mob at the end of the day that descended on the Capitol on January 6th. And I do think there's evidence to support the president and some of his chief staff as having been involved in those activities and in encouraging folks, including Roger Stone and the Proud Boys and all these folks, to encourage others to act. The problem with the January 6th piece, and there's a multiple problems, obviously, but one problem is that when you consider the criminal standard of proof in a case beyond a reasonable doubt, the question is, if you bring charges, and I do think that there's ample evidence to support the reasonable belief that crimes have been committed by the president and some of his staff members and family members with respect to the events of January 6th. If you believe that, and I do think there's enough basis to bring a charge, the question always is, are you going to have enough evidence that you can convince a jury beyond a reasonable doubt that that conspiracy existed, that those acts were designed to interfere with the election, and that is a federal felony criminal charge as well. Do you have the evidence that will actually support such a conviction against the president and his chief staff? And I think that's where people get troubled by it. It's not that we don't have enough evidence to bring the charge. The question is, will we have enough evidence to support a conviction? And that's where I think reasonable people can disagree.
All right, then. What about certain smoking gun moments, like the attempt to get the magnetometers turned off so that armed individuals could enter the Capitol? There's no question about that.
Again,
so that's a crime in itself, all by itself, isn't it?
I would think it is, but it's not. The crime, again, goes to the conspiracy and the attempt to interfere with the federal election. And that is a piece of evidence. This memo I saw the other day fully supports not just the turning it off, but saying do not use weapons or take any type of physical opposition to the protesters without my further authorization, written authorization, I think it even said, which indicates to me, and I think to anyone reasonably interpreting the memo, is that they knew that there would be anarchy on the 6th. And what they were doing was taking steps to make sure that law enforcement wasn't sufficiently able to deter those actions, because there was a real intent by the administration to interfere with the orderly administration of the election and in essence, certifying that election. My personal belief is, in looking at the evidence and in interpreting some of the information the January 6th committee came up with, is not only is there sufficient evidence to indict, but there'd be sufficient evidence for a jury to convict. Another jury might look at the same evidence and say no, but normally, if this was you and I down, I'm from Dorchester, you're from southern New Hampshire originally, but have been a Boston boy long enough. If you and I had committed some type of offense, there wouldn't be all this angst and debating about whether Bradley and Mike should be charged. We'd be charged on this level of evidence, and we would likely already be convicted 2 years later at this point. And that comes to your other question, is politics really what's driving this at its core throughout? And I think undoubtedly the answer to that is yes, unfortunately.
What you think is politics driving?
The non-charging.
The non-charging. Okay.
Right. Or when he'll be charged, right? We all heard, he can't be charged before the midterm elections.
Right.
That'll create chaos. Well, midterm elections are in the rearview mirror, even if the events of the Capitol over the last couple of days say, well, maybe not exactly in the rearview mirror yet.
So yeah, my beef with this isn't political. Like people may say, Bradley J, you're a liberal. Well, first of all, don't make that judgment you don't know. But secondly, the thing that burns me, it's not political. It's if I, as you mentioned, if I had done these things, even close to these things, they would have locked me up and thrown away the key forever, immediately. And I play by the rules, and it really angers me to see scofflaws get away with it over and over and over and over. And further, it burns me to really realize that equal justice under the law is fake. It's not true.
And that's what burns me about it as well, is that, as a law school professor, as a dean of a law school, you try to at least parrot the equal justice under law, that we're treated equally. But I really do try to ask my students to question whether that is in fact true. And that's why we as lawyers need to fight to try and ensure that. But if people really think that the rich don't do better, the connected don't do better, that there is an inequity in our justice system, both from a standpoint of who gets charged, what they get charged with, and what ultimately they may receive as a sentence, unfortunately, that's not true. It's a goal, it's a desire, but it isn't the actuality of it. And that's what's unfortunate, that this could be a good lesson for everybody to say that despite who you are, at the end of the day, you will face the rule of law, and justice, as best we can administer it will be served. And that's, I just can't say, I can say it's not being served in this case, because as you said, you and I would go to jail. Well, a lot of the smaller actors here, the soldiers, have gone to jail, have been sentenced, and their lives have been disrupted. The argument is they were acting on the orders of the President of the United States and his staff. Well, if those orders were illegal and improper, why aren't they in the next jail cell? Or why aren't they at least facing a jury of their peers to be able to decide that issue? And that's where I think this becomes really problematic for people. But I recognize there's a lot of political considerations at work. If he's charged, there's chaos. If he's not charged, a lot of us feel that it's a miscarriage of justice. I know those dynamics are there, but I think at the end of the day, even as a former president of the United States and some of his chief staff members who participated in those events, their action should be judged by the rule of law and a jury of their peers if they choose a jury. And that would give us a lot more confidence in whether the outcome and whether justice was administered. And the longer it waits, the more it gives us all pause as to whether that's going to happen.
So we're with Michael Coyne, Dean of the Massachusetts School of Law, talking about all the potential criminal liability of ex-President Trump and his Confederates. At this point, I'd actually like to see them hold off on actually charging the ex-president till after the election, because that only helps him raise money. It empowers him. I don't mind the chaos so much. It just empowers him when he's being investigated or when he's being charged, makes him kind of a martyr. So I'm okay with holding off on that as long as Giuliani, Jeffrey Clark, Meadows, as long as we see these guys going down in the meantime, and they can be working on them and try to flip them, or maybe they don't even deserve a deal. But as long as I saw some action in the right direction, I'd feel better.
But isn't that a political consideration then? And
it is. It is a political consideration.
And I don't disagree with your stand from a political standpoint. You make him a martyr and he raises money, and it may embolden him and may encourage his supporters to work harder on his behalf, because it does appear that political power is diminishing. If you look at the last election results and what's occurred with respect to trying to seat the new Congress. But at the end of the day, as a lawyer, as someone who believes in the rule of law, I think those considerations shouldn't be a consideration with respect to when and if he's charged. I think it goes back to the point of if he was just one of us, and I do respect people's thoughts that former presidents should be immune from this. This is not what our country does. It's what other countries do to ousted.
You do agree with that they should be immune from what?
No, that immune from any type of prosecution post having served their presidency.
You agree with that?
No, I agree that some people feel that way, and
I see.
I understand it.
I see.
I think in this case, that sentiment is misplaced because we have never experienced such treasonous actions as
Right.
those that took place on January 6th. And I think they have to be at least litigated to see whether those actions were in good faith justified or whether they violate the law. But I do understand how people don't want to be some of these foreign countries that as when the previous regime is out, they're either executed or imprisoned for life. That's not who we are. But there's a basis for criminal charges here. And by the way, when we talk about criminal charges, I think the one that is most likely to be brought because it's the easiest to convict on and with the most evidence is the mishandling of the top secret and confidential documents.
Where do we stand with that?
Yeah, well, that's been a mess as well, but I think that's getting sorted out. At this point now, the question is, did he mishandle evidence, and what mishandled the confidential and top secret documents, and what evidence do they have to support it? To me, based on what the information we have, it's a slam dunk. And he's the one who in 2018 made that a felony with a sentence of up to 5 years in jail for the mishandling of classified documents, in part based on the Hillary Clinton's emails situation. But he is likely and should face charges for the mishandling of those documents. And again, it's not that he might ultimately serve 5 years or 10 years or 20 years, but the rule of law itself has to be enforced, and those rights, and whether he's right or not, that issue has to be judged by an impartial arbiter, whether that's the judge or a jury. But that has to be done, again, to deter others in the future from these types of actions.
Is it safe to say that if he's not charged for that one, then the Department of Justice just is not doing their job?
I would agree with that sentiment. I don't see how you escape charges for that. And again, charges with some type of conviction and some type of penalty doesn't necessarily mean that he's going to jail, because people make deals all the time and
Right.
Accept a conviction or accept appropriate punishment without having to be in prison. And
what would be good is having him pick up trash on the side of the road.
well, just something. So as you said, Giuliani and all of these others who were complicit in let's look at it. There was an attempt to overthrow our government and the orderly elections with respect to the events surrounding January 6th. Is there any crime on the federal level that is likely more serious than treason against your own country? And now that may be hyperbolic, but it's a pretty close question when you continuously, even 2 years later, talk about rigged elections and phony ballots when the evidence just doesn't support it. Every case that any court has examined with respect to the rigged election and the fake ballots and all of that, those cases have not only been dismissed, the lawyers have been sanctioned because there was no good faith basis whatsoever to support those charges. 2 years later, to still hear the same stuff is almost unbelievable.
Now, what about the Atlanta attempt to mess with the election in Atlanta? That's pretty cut and dried. He called up. He's on the phone, clearly interfering with an election. There's no doubt. It's documentary evidence. There it is.
Well, I hear you when you say no doubt and clear evidence. But again, come back to what I suggested about the standard of proof. It's, can you prove guilt beyond a reasonable doubt? And that's where reasonable people might disagree whether he was exercising his First Amendment vote rights to actually ask, are there ballots not counted? Is there a way to see that I could have won Atlanta, or is he encouraging the destruction of ballots and the false counting of others? That's I'm with you, and I understand the point. And on a personal level, I might agree with it, and certainly on a lower standard of proof, I think you could support it. I do not know whether you're going to be able to prove to a jury satisfaction guilt on that beyond a reasonable doubt. And that's, again, where the problems come in. Some of these charges, to me, are a lot clearer and more easily convictable than others. And that's where I think the government rightly, the prosecutors rightly, should be picking and choosing carefully. But it shouldn't be taking this type of time that it's taking. And I think it leads to frustration and questions about the fair administration of justice under the circumstances. And that is a very, very fair criticism of Merrick Garland in this situation, I believe.
So his company got sued. He did not get sued in New York. Is there any possibility of criminal charges relating to that?
Well, some of the, and as you point out, the company was in fact convicted. They had engaged in this scheme, but somehow the person who seems to have his hand in absolutely everything knew nothing about it, or at least that's the argument. You do start to wonder the phrase Teflon Don, which is comfortable in New York, should come into play here, because a lot of his businesses, a lot of his actions, a lot of his cohorts, the people who were close to him, have faced criminal charges and conviction, and somehow the former president continues to escape personal liability on that. I think if they had a stronger case against him, they would have brought it. Could they ultimately still? Sure. I doubt the statute of limitations has run. But again, I think they know he has a reputation of what we call a scorched earth defense strategy, which means he just fights like hell on every single thing to the last drop is exhausted. And when someone does that, and companies do it, others do it as a litigation strategy, you're doing it to deter people from coming forward against you because you are going to use every effort you can to defeat them. And it is a successful strategy in a lot of cases. So I don't think that they're likely to bring a case that's borderline simply because he's going to likely be able to overcome that. That's why the evidence in the strength of the evidence has to be bulletproof for a DA or the U.S. attorney to be able to pursue a conviction against him personally. He fights like hell, and that's why people love him. But that's why prosecutors sometimes are a bit leery of engaging with him as well. They don't like to be seen as losers.
Anything illegal in the taxes that we've seen?
Well, let's talk about his representations that he paid a fortune in taxes and he made tons of donations, donating his salary. I mean, those were, as it turns out, according to the taxes, not much of it is absolutely untrue.
So he said, I'm going to donate my salary. He did not. He said, I'm going to
donate his last year's salary, donated some years.
He said, I'm under audit. He was not.
But again, that's sort of puffing, if you want to look at it that way. Right. He didn't sign statements under oath where you could argue it's perjury. There does seem to be some inflation of the values of his property and his net worth. And if those were under the pains and penalties of perjury, then you do have potential perjurous statements. But those charges are, again, a little more difficult. And also, as we are finding out, more and more commonplace, if you think about the Santos situation in New York, where, you fabricate your life background and how much success you've had and what you've done, and, you still get to be a member of Congress. So I guess you and I have missed out on this. If we did that with a private employer, before we got to our office, we'd be fired. But if you want to go into government service, at least in Congress, not, government service, you probably wouldn't have been found your office that morning. But at the end of the day, he will likely be seated. Puffing and puffery, and to me, it goes well beyond that. is now far, far too commonplace in too many of our elected officials.
I asked before we went on, why is everybody up got their panties in a bundle over Santos and not President Trump? You know, why?
Well, I think the magnitude of Santos is exponentially bigger than Trump. Now, I think with Trump, he's had a fair amount of success. He's had a fair amount of failures as well. But by many accounts, there is a significant success there, including having been elected the president of the United States.
Right.
Santos, on the other hand, appears to have a completely fabricated background. And the question then that makes people worry, or at least makes me worry, is, well, so where did the money come from, and who is he really supported by? And are those people obviously going to be looking for returns on those favors? And that should be very worrisome to everybody. But there is a case from 1967, the Adam Clayton Powell case, which says he, nonetheless, having been elected, has a right to be seated. They can expel him, but they can't deny him his seat in Congress. But it is a horribly challenging situation, simply because in the private world, this wouldn't take place. There'd be no question that someone who had fudged their resume to this extent would not even be seated the first day in their office. They would be terminated immediately. But in Congress, now all of this puffering and fabrication and lack of public service, and more the encouragement of anarchy and all of the rest of the jargon about draining the swamp and challenging the status quo. Too many people are not in it for public service, but they're in it it seems to a large extent, for personal gratification and status. And we should be able to vet everyone a lot better to make sure what their true intentions are. And maybe we wouldn't have the mess that we're in on so many different fronts now.
So the saying is, in the United States, you deserve the government you get. Yeah. And at the end of the day, isn't it our fault that we have the character? It's a post-truth era and a post-character era. The character is not a thing at all anymore.
Well, when you say our fault, I have a little trouble with our, because I think to me, and I've said this in other contexts with people, I think 40% of the people on either side of these debates are people generally of goodwill and good intention. So that leaves us in this 20% category who are not well-intentioned at all, and are more concerned about destruction than cooperation. And so I'm not sure I am willing to accept responsibility when you say our, but certainly there's a fair amount of folks that we tend to accept some of this stuff far too easily, because it's not just the puffing of Santos or Trump, or some would argue Elizabeth Warren. We have accepted and come to accept some of this, what I'll call lack of character, as far too commonplace. And that's so, and me included, and I guess all of us included. But geez, I'd like to think most of us still are people who want to see the right thing done. I think, as we started out the show, I think my folks who have gone into public service are people of integrity and do it for good reason. But if we get the government we deserve, and I think we do, then more of us have to work to get a better government, right? And that falls on all shoulders.
I put myself in our fault because I guess I haven't worked hard enough to convince the rest of the folks that character isn't, I haven't done my part to get out there and make truth and character a thing again. I've been, I guess, I didn't do my part. So I take some responsibility.
Well, I hear that, but,
a little bit, only tiny smidge.
Okay.
No.
Listen, I think most people are people of goodwill. I do think there are those out there that are not. And I don't know how we fix that part of the problem. There are That's the concern. I think one way we try to fix it, at least, again, it's my background, my perspective, is, well, then enforce the rule of law. Enforce it and see where the chips fall. Forget the political considerations. Forget all the other aspects of this. Let's try to administer the rule of law equally to the rich, to the poor, to the powerful, to those that have no power and no voice. Let's see what happens if it really is closer to the goal set by the Supreme Court on the top of the Supreme Court, where it says equal justice under law. If we got closer to that, then more and these character and integrity flaws were carefully examined and scrutinized and subject to the rule of law, maybe people would have more confidence and there'd be fewer people who are engaged in that type of activity.
Before we go, what about Giuliani? Well, what about the attempt to replace the duly elected Attorney General with somebody else, like Jeffrey Clark, who would do Trump's bidding? Is that illegal?
Not really, because if he's not elected, they're appointed by the president. So the president has the right to appoint the Attorney General and then be confirmed by the Senate. So, I mean, there is a process for this that involves, to some extent, the president getting his or her man or woman into that role. It is a selection, and the other presidents have had that same opportunity. What I think you're worried about, legitimately and correctly, is that there does seem to be a manipulation before January 6th, in the months that followed the election, with putting people into positions where they would be able to do the president's bidding, which at that time would have been to interfere with the election in November,
right,
and to keep the president in power beyond a lawful term. Those are crimes.
Right.
That's the problem, and I think you're correct with respect to that. This isn't some scheme hatched on January 5th. Maybe we can do something to slow things down. This is a months long agreement to try and put the pieces in place that would be able to carry out the goal of establishing that the election should be done over and a redo.
Right.
And that undermines our democracy.
I did misspeak. I should have said duly appointed. And the reason folks like Pat Cipollone said, no, you can't do that and we'll all quit, is because the attempt to install Jeffrey Clark was related to illegal activity.
Oh, sure.
Okay. So you talk about a pattern that didn't start on January 5th. That's true. And way before the election, didn't the ex-president say, I'm not going to accept the results if I don't win? Isn't that evidence right there? Look, he's saying right up front, I'm not going to engage in the orderly transfer of power if I don't win. And then the January 6th committee shows a pattern of different methods to attempt to do that. And when they all failed, violence was the last resort. It seems like if you were a member of the core of reasonable persons on a jury, you could not make that connection. But it's going to be, that's, by the way, tough to find juries. You think that weighs into why they're not acting? Because how do you find a jury that's actually impartial at all?
Well, you correctly stated the standard: impartial, and will judge the case on the evidence presented at trial. We don't get a jury that knows nothing about it, because a jury that knows nothing about January 6th at this point would be living under a rock. You wouldn't want them on your jury. So you correctly stated the standard. It's impartial and will judge it on the evidence presented. It will not be easy. But at the same point, remember, we were able to do that in Boston with the marathon bomber. We've been able to do it in other high-profile cases. There are people who will look beyond what their personal views may be and then adhere to their oath of jury service. But is that going to be easy? The answer is no. And I don't think that would be part of the calculus here by the attorney's office. What would be part of the calculus would be, are we certain or sufficiently comfortable that we'll get a jury that isn't half Trumpers and half Biden people, so that we don't get a conviction, or we don't get, we just get a mess. And that's would be the concern is, will we be able to sufficiently vet a jury to get them so that they will evaluate it on the evidence and not be infected by politics? That you do have to think that that's a concern. And that's a concern, by the way, in every high profile case. People will lie about what their predisposition on the evidence or the defendant's guilt may be, because they want to serve. We actually saw it in the Bulger case. We've seen it in many cases that people want to sort of get the semi-celebrity status of sitting on one of these high-profile cases. And it wouldn't be much of a higher profile case than the trial of a former president, either on conspiracy charges or mishandling of classified documents.
How do you feel about a professional jury that's trained, certified, they understand the proceedings in the law, and they're I don't know, perhaps judged every so often? I'm sure that comes up. What do you think?
Yeah, I don't like it. We do have what we call blue ribbon juries when it's a highly technical case, then that people talk about, well, let's get a group of experts in. But I really do like the system that we have that says, at the end of the day, we bring 12 people or 6 people in from the community of reasonable intelligence, we hope, who are going to bring common sense to bear on the question. And more often than not, juries get it right, I think. So I like the system we have, and I do think we would be able to, at the end of the day, and it might take a bit, but get a jury that will view it carefully. And I think that brings more confidence to our justice system and the results that we reach, if in fact we involve the community in this process. Because otherwise it's all these lawyers who went to school forever, judges who have their own affiliations and the like, and a lot of money obviously involved in most of these cases. And I don't think that fosters trust in the results or in our justice system. I actually really like the system we have. If you don't want a jury, you don't have to. You can have the judge resolve the case. But I like the fact that ordinary people are brought in to use their common sense and make sure that we get it right.
All right. Excellent session today. I really appreciate it. 37 for almost 40 minutes. You look great. It was fun. It was fun to speak with your son the other day. He did such a great job. That was great. 2 days ago. Tell him thank you for me.
I will.
I look forward to speaking with you soon, and stay healthy and have a good start of the new semester.
You too. I'll talk to you soon.
All right. Bye. We'll be clear in a few seconds.